These speakers are here today to offer their unique insights to the modern treaty process, specifically the Nunavut Land Claim Agreement with Bruce, the James Bay and Northern Quebec Agreement with Mandy, and the ongoing Algonquin land claim being negotiated in Ontario with Veldon here today. This is all I will say about them today, as they'll be introducing themselves in just a few moments. And there was an itinerary change, so I continue, actually. I'm so sorry. When we first started planning for Treaties Recognition Week, many ideas swirled around the brainstorming table. We thought we could highlight and focus on one particular treaty area or discuss the various types of treaty which have been signed since contact. As fascinating as these topics were, we wanted to ground the conversation in a more contemporary setting. We thought it would serve as a reminder, as fascinating, okay, I messed up, sorry. We thought it would serve as a reminder that treaties are not only a part of our history, but are also part of our day-to-day lives. Treaties are not these completed processes of the past, and they continue to be negotiated to this day. With that being said, we turned our focus to modern treaties that were signed in our lifetimes. We will discuss the differences between historic and modern treaties and talk about the potential effects these new agreements have on our future treaties and possibly even on the ones of the past. I also think it's a big learning opportunity here today for everyone. Senator Murray Sinclair once said, "We can't change the past, but we can change our understanding and our knowledge of it and our response to it." I think learning about treaties is a tremendous learning opportunity today. So, did I show you how to turn on your mics? Okay, they're on. Fantastic. So, at this point, I would like to give our panelists an opportunity to say hello to the audience and to introduce themselves. And by roll of the dice, it is Bruce who will begin.
Okay. Good afternoon. My name is Bruce Uviluq. I work for Nunavut Incorporated. That's the organization that represents the Inuit of Nunavut. We have a treaty like that Mandy's going to talk about. I've been working for NTI since 2002, and mostly in negotiations against the federal government on some of our treaty obligations, which I'll be talking about later. So I work for NTI as a legal negotiator, and hope to share some of my experiences about the modern treaties, challenges that we've faced, and also the history.
Thank you, everyone. My name is Veldon Coburn. I am from here originally. Well, at least, I'm half settler, half Algonquin. I'm a member of the Algonquins of Pikwàkanagàn. I'm currently teaching Indigenous issues in the School of Indigenous and Canadian Studies at Carleton University, and just finishing up my PhD at Queen's on Indigenous politics. My interest is more around the politics, I guess, of treaty negotiation and some more internal issues of, nation to nation, what have you. So did you want to say something?
I was going to say, yeah, treaty negotiation and even implementation is never a pretty thing. So that's why Veldon's here to talk about a few of the issues that he's experienced or his community is experiencing currently right now. I think it's going to be a very exciting conversation.
Yeah, we'll talk more about that. Thank you, and thanks for having me.
Mandy Gonsangason, Nistum Yamun Gamstan, Nuhajamodan Jidiud Ganador, Utenhanjis, Naskan Win Skamat Ganjid Algonquin, Eunebit Batsnated, Jajidaik, Utenhau, Naskajwi, Jinskum Noga Duxniak, Kagnui, Namaskamaga Chemando Jimiate, Mina Jisgajajiwatmik. I speak in my Cree language first because it is very important to the Cree Nation to maintain and use our Cree language. So what I said was, I would like to thank my fellow Crees that I see here today. I'm glad that you all made it. I would also like to thank the Algonquin Nation for allowing us to be present in their territory today. And my thanks to the Creator for giving us a new day and for all of us being here together. My name is Mandy Gull. I'm the Deputy Grand Chief of the Cree Nation of James Bay. I am very pleased to be here and to meet my fellow panelists. I am the politician in the group. So I think I'm going to offer a unique perspective. I think we all will have very different backgrounds, but I'm excited to be part of the panel today and have this discussion. Thanks.
Miigwech. Oh. Okay. Is this on? Yeah. Miigwech, everyone, for introducing yourselves, making me feel bad for not starting in Cree. Thanks, Mandy. But I digress. Yeah, shout out to the Crees and everyone else in the room. That sounded mean. But we were having a little talk at the beginning of the day. We were running a little late, but we talked about the best way to start the conversation about modern treaties or treaties in general. So we thought that an introduction of sorts to explain the differences between historic and modern treaties would be the most appropriate way to begin. And we drew straws, and Bruce got the shortest one. So he has volunteered to start a little bit there, and from there we'll proceed with the conversation.
Yeah. Hello. As Darren said, I think modern treaties, which were a departure from the reserve type system that were in existence from the numbered and historical ones, and the modern treaty process began long before the first modern treaty was signed. And so this began in Alaska, and the Inuit there, as well as the other modern treaty holders, they knew they needed something to prevent government and big business from doing whatever they wanted on their land. In this case, in Alaska, how the first modern treaty came about was the Inuit up there weren't given much attention until they discovered oil in Prudhoe Bay. And that time in the 70s, there was a gas shortage, and so the U.S., Washington, wanted to get that oil out. And so what they proposed was to build a pipeline from Prudhoe Bay across. They wanted to detonate a modified nuclear device in the port right by the communities, so they could create an instant deep sea port to start getting that oil out. Of course, the Inuit, who relied on the animals, fish, whales, polar bear, everything, they were going to be severely affected. So what happened was the Inuit filed an injunction against the pipeline going forward, which stopped the development from moving forward. And also, just to speed up the story, is that if it wasn't for the Washington oil executives who lobbied Washington, D.C. to say, we need to get this oil going, and how they wanted to do that was to recognize the Inuit rights there, and that led to the first negotiation, first modern treaty, and whereby it got away from the reserve type system, and the Inuit exchanged their Aboriginal title for rights and benefits in what's in the first modern treaty. So there was capital transfer of $963 million, different titles to land, and also fishing and hunting rights. But that set the stage for the first modern treaty, 1975. The next one, and the first one in Canada, Mandy's, the James Bay, Northern Quebec, that was a similar issue. It was about resources, whereby the province wanted to erect this huge dam, no consultation, flood the lands, the Inuit would be affected. So the same thing, they filed an injunction, which led to the creation of the first treaty, which was negotiated in 2 years, and similar things. I think Mandy can talk about the details about the monetary amounts, the different land ownership, and also the rights and benefits. So those were the first ones, and there were comprehensive benefits in exchange for Aboriginal title for those. So there's James Bay, Northern Quebec, in Uviluq, 1984, and that was because of the oil and gas in the Beaufort Sea, and then also the Nunavut Agreement in 1993. So these comprehensive modern treaties ensure that are constitutionally protected, ensure that the Indigenous group is involved in decisions that affect their land and rights. I think we'll talk about some of the details of those, but that's the basis of what modern treaties are. And it's a big shift, and Darren mentioned this earlier, that we feel that it's a fair, good consideration given in exchange for Aboriginal title and rights. So that's a little bit of history on modern treaties and how we got here where we are now.
Thank you, Bruce. Would any of the other panelists care to add on to that history of treaties?
just quickly before Mandy jumps in, is that treaties, and it sounds really unique in these terms, but let's note also that treaties are nation to nation too. They're international instruments, and these ones that we'll speak to today involve land and Indigenous rights. But it's not uncommon in Canada. We just signed one with the United States and Mexico, right? This was an economic, it referred to trade and commerce, and we see what's happening with Brexit in Europe as well. Treaties, again, nation to nation. Some of the historic ones that, I mean, we didn't touch on it quite as much, but wampum belts, diplomatic instruments, we can tease that out a little bit later on in the discussion as well, but the key point that I want to raise is they are nation to nation as well. So.
It's a good addition to the definition. Mandy, did you care to add anything?
Thank you. Yes, I would. First, I would like to acknowledge that we are in the presence of a treaty provided here today. I was very excited to read it, and I was surprised at the quality of its preservation. I even asked if that was the original one, because it looked so good. It looked like it had just been, coming off the printer, so I was a little bit surprised. I would also like to acknowledge that in this discussion, I'm also here to learn. I'm not aware of a lot of the other treaties, so I'm excited to be receiving this information from my co-panelists. The one thing that I think today's discussion, what I hope that I bring to the table, is really an understanding of the treaty process and what it means to be part of that process through the eyes of the people that negotiated. I was very lucky to have entered into the political domain of my nation at a very young age. So I had the opportunity to work and meet and have discussions with many of the people that negotiated the James Bay Northern Quebec Agreement. This November 11th, we celebrate Remembrance Day, but it also marks the day in which we recognize the signing of our agreement. So that will be a very special day for us next week. We did sign our agreement and negotiate the process in a very short period of time, which is extremely unique. Usually, this is an ongoing process. We had discussions earlier. It ranges from decades to sometimes even centuries. And the fact that the Cree Nation sat at the table and had a very intensive discussion and reached an agreement between two parties, the language that we also use is nation to nation. My treaty is unique because we are the Cree Nation of Iwishchi. Our nation that we have reached an agreement with is the province of Quebec. So we have a very close working relationship with Quebec. We do have a relationship with Canada as well. I hope through the discussion to kind of explain how we've built on our treaty process over the past 45 years in our territory. But I really hope to share today, every treaty comes into its being based on different things. In our nation, when we heard of the project of the century, when Bourassa announced that he would be damming and creating this opportunity to bring Quebec to the forefront of being deliverers of power in Canada, it was actually a woman who called attention to this. And this lady recently passed away. Her name was Anne-Marie Washish. She was actually, at the time, I think the girlfriend of Philip Washish. And she called Philip. Philip is one of the signatories. And she said, hey, did you see the news that the premier is going to be building a big dam in the Cree territory? And nobody was aware. So I really have to acknowledge that Anne-Marie played such a significant role. And I think that it's really important that I also acknowledge that many of the faces in the crowd today are female. And that's really important to me as a female in the political world and in the Aboriginal world, to see that there are so many women interested in this subject and coming here today and participating and learning. I just want to call attention to that because I think it's new and emerging for me. I didn't expect that, so I'm pleased to see so many women here today.
Thank you. 65% of the student population at the University of Ottawa are people that identify as being female. So there are a lot of women here in general coming to get educated, and it's also, something that's really wonderful to see. So thank you all for your words as we try and provide a brief sort of overview of what the history of treaty looks like from historic to modern. And we touched on a lot of things there. And I think just starting from the top, I was wondering if we could maybe explore what it means when you say Aboriginal title. Because Bruce, you're talking about modern treaties being negotiated like in exchange for title. And I think that's something that could use a little bit of an elaboration. And I think it's also another opportunity for our fellow panelists to discuss what that means with our audience.
Okay. Yeah, from the Nunavut perspective, back in the, because our treaty took 20 years to negotiate. And I'll also add to Mandy is that we had to borrow money to negotiate, and Nunavut is fortunate that we're 1/5 the landmass of Canada, 40% of Canada's coastline. Our traditional territory is very big, so we had a lot of money to borrow to negotiate. So we borrowed $39 million to negotiate our land claim, which took 20 years. The challenge also on that, a challenge in modern treaties, especially in BC, where I think there's 26 tables negotiating right now, they get little money to negotiate based on their population. Some of these treaties are small, hundreds or just a few thousand, so they get a very small amount of money to negotiate. And once they run out, it's the take it or leave it approach that the government uses. So what is important there is there is what used to be known as the extinguishment clause, and we don't use that language anymore. Veldon and I were chatting about that. That was the original language that was used in the historical number treaties, where the First Nations extinguished their Aboriginal title for the rights that they got in those treaties. I believe it's also in the James Bay Northern Quebec Agreement Act, but we want to get away from that language because it's very negative. And a treaty creates clear title for the Indigenous groups and also for Canada, for the Crown land, for resource development. So what the modern treaties do is we cede, surrender any rights, land, in exchange for the rights and benefits. And I'll just hold this up, I brought one. But this is the Nunavut Land Claims Agreement, 42 articles, 193 pages, but it's a very comprehensive, constitutionally protected agreement of how, when things happen in Nunavut, what will happen. So it contains how Inuit will be involved in co-management structure that deals with land use planning, water, impact review, disputes and surface development, this kind of thing. I mentioned that there's a land component, so all the modern treaties have land component as well. So Nunavut, we own 18.5% of the total land, 356,000 square kilometers of surface land and 3,500 of subsurface, and so we get special rights and benefits for any development that happens on those. Also, Inuit are the largest private landowners in Canada. So, and also there's a financial component. So part of what we got in our agreement was $1.1 billion in capital transfer. And so we operate off the annual interest, and that money's held in trust. We never touch the principal, and we're not reliant on the federal government to implement our land claim agreement, which gives us very good autonomy, and our mandate is very clear. So that's basically what a modern treaty is, an exchange of Aboriginal title for rights and benefits that are contained in our agreement. And so, yeah, ours took 20 years to negotiate, and that's why we work very hard to ensure that our agreement is implemented. And I'll talk about some of the challenges that we've had, including our $1 billion lawsuit that we filed in 2007, and some of the positive changes that government has been forced to do in the face of litigation, which I think will have positive changes for revisiting the historical treaties, but also informing current and future negotiations.
I might say about Aboriginal title is, well, title being ownership of land, but one of the aspects of colonial settler politics is the fact that the Crown claims something called radical sovereignty or radical title, is that just because of their presence here, they already view themselves as sovereign over these lands, despite the title having been ceded or released or surrendered. Again, some of the past language that has been used is extinguishment of Indigenous title to the land. We still retain protected rights under Section 35 of the Constitution. Some of those fall within, the hunting, fishing, and traditional practices and customs that were land-based, territorially based, what have you. But there still is the assumption of the colonial settler state of having title to it, irrespective of the fact that we've never had a treaty, especially here with the Algonquin. It's never been ceded. We've never been conquered, but the Crown does claim sovereignty over this territory, as it were. That was a policy that has been ongoing and enshrined within the Royal Proclamation, 1763, where only the Crown could acquire title. That was the only body that could acquire rights to the lands. For instance, the Algonquin people could not sell to a private person, and for the private person to create their own nation of sorts and declare independence, it was always to be consolidated under the name of the sovereign, the British sovereign it was. So there is that issue of transfer of title, lawfully acquiring title, but in Canadian jurisprudence, it always goes back to the legal fiction that the Crown is sovereign over this territory despite never lawfully acquiring it thus far. And that's part of the impetus for the Algonquins of Ontario modern treaty negotiations, although there have been a few what the provincial government refers to as treaties, namely the Crawford Purchase and the Rideau Purchase of lands. It did not extinguish or modify Aboriginal rights under the Constitution's Section 35 protections, nor did it adequately under law transfer title or cede, release, or surrender to the Crown. So that's an issue too that's in negotiations, but goes back to the idea of Aboriginal title is that we may, if I were to relate to you, we may be private property owners in our minds. We have a deed to, say, our own real estate, but we do not own title to the underlying land that always is vested in the sovereign. It's different than what in the United States is. You can be private property owners, but they will not allow you to buy enough property to create your own country. You still fall within the ambit of the states. But that's a big issue that's at work here.
I think I'm a little bit conflicted about, the idea of title, because I really believe that title is in the eye of the beholder. Like if we would be asking Quebec, what do you think title means? I'm sure that they would have that. The feedback would likely be, you've seceded, we recognize, we provide, X for what you've acknowledged that you've handed over in an exchange. When you sit on the Cree side of the table and you ask that question, the response will be, you have recognized my right and you have recognized my being in the Cree territory. So I really think that title, debate it, talk about it, it's really in the eye of the beholder to me. And I say this because every time I've had a discussion with the individuals that have negotiated, they have never said, we have signed away or we gave away. They have always said, Quebec recognized that we were here. Quebec recognized that we hunt, fish, and trap in our territory. And the way that the JBA and QA came to be when, Anne-Marie had informed this young group of men who were, in their early 20s here, some of them here in Ottawa, some in Montreal, there's going to be a project. These guys got together and spoke to each other and said, we cannot let this happen. And one of the reasons why I think they felt that they had to take this task on was language barrier. And my community of Waswanipi, I am one of the communities in a group of 10. We formed the Cree Nation of Iwishchi. We're 300,000 square kilometers. We have a very large land base also. I think that really did help us a lot in the way that it helped the Inuit. It helped us also. We're 20,000 strong. At the time, I think we were no more than 9,000. So we've really grown in the past 40 years. But these guys got together and they traveled from each camp. At the time, there was no fixed community. They went from camp to camp to camp and told their elders and told the leaders at that time that, hey, Quebec is doing something, and explained to them, because not only was there a language barrier from Cree to English, but in Quebec, French is the predominant language of the province. So we had a multiple language barrier. 40 years ago, people were not living in houses, they were living in camps, they were traveling, they were going from their summer camp to their winter camp, they were traveling as families together. So we really encountered this rattrapage, as they say in Quebec, trying to advance rapidly the same way that Quebec did. And to me, the fact that we were able to reach this agreement was really an initiative of both parties to want to move forward. I think on the Cree side, as much as they were concerned about not having the recognition, they also wanted to offer that opportunity for development to the Cree Nation. So I am conflicted. I've only ever grown up under the JBNQA. That is all I know. But recently I had the opportunity to visit another nation in Europe, and I'm sitting here and the Sami people are explaining to me a mining company wanted to come and do this, a forestry company wanted to do this. And I had to sit there and I had to say, yeah, that happened to us too, and we have an agreement because we accepted that process. So I guess, it's very harsh to say, but it's a blessing and a curse, And I've had elders say that to me because, yes, you get the opportunity for development, for education, for healthcare. There are 28 sections in our agreement. Some have brought incredible opportunities to my people that they would have never had. But at the same time, I go to meetings and I sit with elders and I listen to tallymen and I listen to trappers, and they say, there is an impact on my trap line, and this is how I know, because in 40 years, my activities have changed from this to this. So it's a difficult process to be in, and it's really difficult to see as, a holder of this process, how I can take on the initiative or the mandate to implement with that mindset that somebody else is coming after me, and you have to be aware. And I think that's the part of title that we have, as Aboriginal people, have to be aware. You're not only holding the title, but you have to pass that title to the next generation coming in after you.
Right, thank you. And I didn't want to rush anyone during the discussion about title, because I think it's a really important aspect because it comes up a lot. And sometimes we're talking about definitions varying from person to person or from or nation to nation. So thank you. But a lot of the responses sort of touched on community, like we were talking about the history before the JBNQA and how the people got together there. So I thought I would like to ask a little bit more about community involvement then and now, because particularly for Veldon, with a treaty being negotiated right now, and just its location, the size of the land that's being negotiated, and the number of communities, it's kind of like a big complex issue where, as a Cree person, and I hope you don't take this in the wrong way, I find we know who our people are, and for the Inuit as well, I think they have a very clear idea of who their people are. But how does community engagement or involvement look in your area? And if anyone else wants to answer after, they're free to do so.
Sure, that's one of the biggest political issues, and it's emerging a little bit more to the forefront. You have to go back to when the petition to the Governor General or to the Crown was made by my community in 1983, which spurred what is currently now the negotiations. It took 34 years for the agreement in principle to be signed. So it was slow moving. It's a big treaty. However, the idea of who community is has changed in the last 10 or 15 years. It was started by my community, and we're the only, I guess, status community of the Algonquin communities on the Ontario side. But in the last 15 years, there were groups, and again, this goes towards the definition of what a nation is. These are nation and nation instruments, and a nation is a people of a common history. And sort of out of the woodwork, those of us from our community, we knew who we were, as you said, just as the Cree who knew who they were. There were these sort of interventions by what is largely viewed by a lot of the Algonquin, especially the Algonquin on the Quebec side, because they're excluded from discussions and negotiations of what it would be effectively the secession of a portion of the Algonquin territory, is who has a say in this and who is the community that comprises the Algonquin nation. Well, in the last 15 years or so, people have been shaking the ancestor tree and finding an ancestor from the 1600s and saying, well, I'm Algonquin, based on this particularly tenuous ancestry, I should have a say, which would effectively extinguish or significantly modify Algonquin title. That being their only ancestors of sore point amongst Algonquin, especially those on the Quebec side, where 9 of the 10 status communities, as it were, reserved First Nations, are being excluded. Those who are part of and have never said, well, I'm not Algonquin, I've only known myself as Algonquin, but those views and their own rights to the territory, because it's a shared territory, just because it's been bisected by the Ottawa River, and that was part of the Crown's 1791 surveying. The split of Upper and Lower Canada arbitrarily partitions the Algonquin nation, but divides the Quebec Algonquin and lets those who might have not had any Algonquin ancestors since, say, even 1609, some of these root ancestors, as it were, provide rights for these individuals who overwhelmingly, in the majority, are voting to effectively extinguish Algonquin title. They have greater franchise in the negotiations, so it's not entirely nation to nation, because it excludes almost 80% of the Algonquins and includes those who, ironically, would include Justin Trudeau, because he does trace his lineage back to one of these supposed root ancestors. And these root ancestors have been contested by my own community. It's gone before a hired ex-justice of Ontario Superior Court to adjudicate, and on a balance of probabilities, which is like 50-50, right? Is like, they provide, say, a baptismal certificate from the 1600s and say this person was Algonquin. It doesn't say that they were, but it doesn't not say that they weren't. So on a balance of probabilities, they'll allow this person to be Algonquin, and for the sole purpose of only ratifying, and it was for the agreement in principle, which will effectively become, the text will change very little from what it will become in the modern treaty. But there's sort of this perverse paradox and paradoxically perverse idea of these individuals who won't acquire rights, who won't acquire any per capita payout, that some people think, well, hey, there's a number figure on the table, just like with you received over $1 billion. It's a capital transfer. It's not per capita or individual payments. The idea that you can become Algonquin just to undermine Algonquin title, deny the other Algonquins with the misconception that you'll get a payout or a personal check cut to you. It's quite a sore sticking point. So it goes to the idea of what is a nation? Well, we're negotiating with those who would participate or who would align themselves more with the Crown, so the Canadian nation, and thereby, I guess, forever, as long as it could be, extinguish Algonquin title to this part of the nation. Yeah, thank you.
Thank you. Were you going to add, Bruce?
Yep.
Okay.
Just talking about the departure from the unilaterally sought and the treaties done by the historical numbered ones. So for Nunavut, we have an enrollment section, and Inuit are the best to decide who's an Inuk. And so there's criteria laid out, and we follow it. And a person can move from their, say, Inuvialuit, leave their Inuvialuit and become a Nunavut beneficiary. They would have to not get any more Inuvialuit benefits, but if through the committee, it can be done. And so we've had Greenland Inuit become Nunavut beneficiaries and this kind of thing. So we decide who becomes a beneficiary under our land claim agreement. I'll also add too is that an interesting provision, and because Inuit, we don't have trees, have been completely reliant on the animals, food, clothing, shelter, everything. So harvesting is the biggest article in our whole land claim agreement. And the negotiators, they knew that there was going to be a lot of white people, coming and marrying the Inuit women. So They wanted to keep the culture and the aspect of harvesting, and so 5734 provides that Inuk can transfer their harvesting rights to a non-Inuk. So Inuk woman can pass on her harvesting rights to a white husband, and so that he can continue hunting and have all the benefits and keep providing country food for Inuit. So there's interesting provisions about that, and I would say that the modern treaties, each one, have a different way of interpreting what those are, and each one is unique and distinct. So just wanted to add that.
Yeah, and noticed a little bit of hesitation when you were defining what Kalunat means. Charlie Hale is like this, one of the first big Indigenous comedians, and he used to talk about that a lot. And he said, whenever I say white people, I mean everyone outside the room, in case there's any awkwardness. So don't feel awkward about that.
Could I add something real quickly, just to relate about the nation? I'll just really quickly is in recent years there has been the independence referendum in Scotland, and I imagine many in this room may have a very distant ancestor who was Scottish. For what is happening with sort of what I view as a secession from the Algonquin nation is basically the Scottish secession, the transfer of title back to the Scottish nation from underneath the British Crown. Is Scotland didn't allow everyone in the world to, with an ancestor from the 1600s, to vote on their independence, to effectively, secede and become an independent state from underneath the British Crown. So this is something that is occurring here for the Algonquin nation, and it's. I would almost wager that there's dozens of you in this room today that could probably trace your lineage back to one of these root ancestors, because 12 generations back, we all have about 10,000 ancestors in total. And that's how Prime Minister Justin Trudeau has his own lineage back. 1 out of 10,000 gives you a right to extinguish Algonquin title. So it doesn't seem, there's a question of justice there, and who has a right to say on territorial integrity and the breakup of a nation. So. Thanks.
Thank you. I probably have time for like 2 or 3 more questions before we turn it over to the audience. So I think I'd like to kind of move towards implementation and governance really quickly. And I think this question will be for Mandy. I know that the Nunavut Agreement has provisions in place to ensure that like the Inuit are involved with the governance, like implementation of the treaty. What can you tell us about the JBNQA? Do you have any sort of similar provisions in your agreement? Like, how does governance look like within your modern treaty? As our sole politician here this evening, or this afternoon, I think you're the best person to answer that question.
I think that I'm going to talk a little bit about the implementation of the JBNQA and how it evolved over the 40 years. So what it essentially created was, we came 40 years ago from families that were traveling within their hunting territories, where everybody was kind of grouped into their own communities. So you were assigned, a band number, and you were part of this community. There's 10 communities, but within those 10 communities, there's inland and coastal. So I'm inland, I'm from the most southern community, our dialect is distinct, but then everybody who lives along James Bay is coastal, and they have their own unique dialect as well. I'm married to a coastal boy. I love those coastal boys. But what it also created was, when the JBNQA was signed, the Grand Council of the Crees. So each chief of each community had a seat on the Grand Council of the Crees, and they selected a Grand Chief. And our Grand Chief kind of had that relationship with the government, and the communities were charged with the implementation of local initiatives. So they took care of housing, infrastructure, community decisions. And the regional level, we primarily focus on strategic direction and implementation of large files and negotiations with both the federal and provincial government. So that came into play. That was a completely new structure. Before pre-treaty, our communities naturally selected their leader. The term that they used was Gaganop Magnot, the person that everybody looks to was the natural leader of the group. When we had JBNQA, it also included an election code. So we started having this chief in council, running for chief in council, having a very non-Aboriginal structure for governance, I feel, because it became very political. Now we're politicians, we're chiefs, but we're also politicians, in the true sense of the word. When the JBNQA was signed, I think every party came into this agreement with the intention that, this is fine and dandy. But of course, with each transition of a new government coming into power within Quebec, we had to reteach the meaning of the JBNQA. And as it transitioned from liberal to PQ, we had barriers. We had to really kind of adapt our relationship to each of them. And as Quebec transitioned into resource extraction or resource development, they interpreted the role of being a party to this treaty, I guess I would say according to their needs. When forestry came into play and they did a lot of extensive forestry in our territory, we had to launch a lawsuit, which was the Pédé Brave. It was reached under the Grand Chief Ted Moses, where he had direct negotiations for 6 weeks with the recent passing of Bernard Laundrie. He was one of the individuals that negotiated a built-on treaty, acknowledging some of the issues that we had. Forestry and resource development is outlined. There are bodies which we sit at tables jointly with Quebec, but this process doesn't always work. Sometimes you have to take it back to the table and renegotiate it. So we did encounter this process with Pédé Brave. We did the same thing with the Cree governance model. We redefined new terms of governments. We now govern jointly with the Jemezien of our territory. We have a new level of government where it's half Cree, half Jemezien, who are the Wemshtagashu of our territory. I'll throw in my word for non-Cree individuals. And then most recently, this past spring, we entered into a new agreement with Canada, which is the Cree Canada Governance Agreement, where we are now working on developing a Cree constitution and recognizing our rights as Crees within our territory. And we've taken on a very big role for self-governance. So we're moving rapidly in 40 years through a progression of treaty, some of it working, some of it not, but nonetheless moving forward.
Will anything regarding governance be included in, or has anything been included regarding governance in your agreement in principle, Veldon?
Yeah, we will negotiate self-government afterwards. I am interested in hearing the implementation from both, especially around private land holdings, because some of our land will be converted into fee simple. And Bruce, you had mentioned that the Inuit maintain 15% private, 18%?
18% of 1/5 of the landmass of Canada.
Mm-hmm.
Anyone good at math?
Well, I can tell you the landmass that the Algonquin of Ontario will be left. We will be left with 0.03% of what we originally had. The landmass that is going to be transferred is about 990,000 hectares, and we'll be left with about 456. A little bit of fee simple, and I was interested to hear. And fee simple is alienable. It won't be protected land. It's a different land ownership. I saw what happened this spring with the Nisga'a, with their treaty, which was finalized just about the same time that the Nunavut land claim was in 1999. Years took effect. You signed in 93, but they put their fee simple land up for auction this year. 20 years, less than 20 years. So I understand now that 20 years. Did you have fee simple land transferred or provided?
I think ours is a bit different because in the territory that we have maintained access to our full territory. We do exercise our right to hunt, fish, and trap in all three categories of our territory. So we have three, Category 1, Category 1A and B. Part of it is federal, part of it is provincial. This is held in the jurisdiction of the local chief and council to govern, to legislate within that category. Category 2, where we are still allowed to hunt, fish, and trap, we share joining powers with our new USG Bay James regional government. So we govern this territory in conjunction with the non-Aboriginal people living within USG. And Category 3 falls under the responsibility of, I got that. Yeah, category 3, we're still allowed to hunt, fish, and trap. It varies in terms of jurisdiction. You know, we still have a very close relationship with Quebec, but we also provide input in category 3. And category 3 is really the table where planning for land use and stuff is done at the regional EOSG James Bay regional government level. We have a lot of authority on category 2. So we at the Cree Nation government have predominant authority, I would say, because we do all of the land use planning and we do all of the negotiations for what's going to be happening in category 2. We take the lead on that. So we're sharing it, but we still have the right to hunt, fish, and trap throughout our territory, as well as build cabins. You know, there's a vary on what can come into play. We have first right of refusal on some of the categories, but I think we have a very close relationship with our whole territory, which is something that's unique to the Cree, to the JBNQA.
I saw that Bruce looked a little eager to contribute. I will allow you that time if you would like, but we'll have to keep it brief, and then I'll have to...
Sure. No, it's just a little interesting story on the governance and how in 93, when we were getting close to the finalization of our agreement, a political thing sped up our agreement and forced us to concede on not having self-government. So at the time, and actually this is a good story because in 1992, 1993, it was the big Oka crisis going on. And this is timely because in that case, it was the government granting a license to expand this golf course onto the traditional territory. And so, of course, the group, we know what happened, that was there. So Canada wanted to have a good news story. And so they said, get this agreement done. And so if it wasn't for that, we may not have the Nunavut agreement there. But it forced us to concede on not having self-government, but having a form of public government and creating the territory of Nunavut and the governments of Nunavut within our agreement, Article 4. So we have a public consensus government, which is not self-government, which has challenges in itself, but it's a unique situation. But it was just that story about how we got our agreement and how our governance in Nunavut is a little bit different than other modern treaties.
Thank you. All right, so just before we turn it over to questions from the audience, I thought I'd give everyone maybe a minute to summarize, maybe like say something that they didn't have an opportunity to address, but they had hoped to discuss at today's discussion. But I guess we'll start with Veldon. If you want, you can monitor this little stopwatch, and then
I hadn't even thought. There's so much to say. One of the things, actually, the points, and I teach it in my own classes too, and it's actually on the James Bay Cree, is that the flooding wiped out, and this is how profound it is, landmass that you've been connected to for thousands of years. The flooding was over 12,500 square kilometers. That is the size of Lebanon. That's larger than the size of Lebanon. It's larger than the size of Jamaica. It's wiping out that landmass from the Cree Nation, and that's one of the more profound things. But for my own nation, there's so much to talk about right now too. Is that, but that's also profound alienation too from everything, and from the Nishkas, that we're looking down the road. The Nishka gave us a sign of what's going to happen in 20 years. Is that we're going to inevitably alienate this land, and the most profound point is, why are we even negotiating to sell away our own land just because other people arrived on it? Mm-hmm. Just to retain what we had prior to it. Whatever trajectory and political autonomy, why are we negotiating with a gun held to our head? Yeah. Somebody wouldn't show up in your house and say, well, I'll let you keep the bathroom. All right? Maybe the shed in the backyard.
I have one story like that, actually. Just
okay.
Kidding. Mandy or Bruce?
Okay. I'd like to talk about implementation. So we signed our agreement in 1993. Territory of Nunavut was created in 1999. And in our view, signing the treaty was like entering a marriage with the Crown. But the Crown saw it as a divorce. So in the early 2000s, after we signed our agreement, the government was not implementing our treaty, just outright not responding. And the difficulty there is that in our treaty, the ultimate form of dispute resolution is arbitration. And arbitration is an independent third party, look at the dispute and they say, Government of Canada do this, or Inuit do this, whatever. The problem with arbitration in our agreement and all subsequent modern treaties is that dispute requires consent by all parties. Government of Canada took the position that they would not consent to any disputes for arbitration. So we had no way to resolve our disputes. And these are major significant disputes that we're putting forward for arbitration. Funding for Inuit employment, funding for impact benefit agreements. There was 14 main points that led us to file our $1 billion lawsuit in 2007. And to make a long story short, we settled out of court in 2015, 6 months before the trial was about to begin. So we agreed on $255.5 million. $5.5 million was costs, which is government had to pay. That's how much it cost for us to be there. And so we got $255 million in damages for breach of our treaty. We get criticisms about saying, what, 255 from 1 billion? But the main thing, the most important thing is that now we amended our agreement so we have binding arbitration. So now when we have disputes with the federal government, we can start arbitration unilaterally, whereas we weren't able to before. And our preference is not to litigate. It cost them $5.5 million, took 9 years. We just want specific performance. We surrendered our Aboriginal title in exchange for what's in there. We just want to make sure that it's implemented and the Inuit get the rights and benefits that we took 20 years to negotiate.
And I was just going to say, what Bruce continues to point at is his Nunavut agreement that he walks around with and carries at all times.
No.
And I'm the person that said, what, from 1 billion to 255? He schooled me quite well on that. I'm sorry to cut you off there, Bruce, but I'll move it to Mandy. If you have any final thoughts you want to say before you go to the audience Q&A, this would be the time to say it.
I just want to share that I think, each of us represents that treaty negotiation is a process that transitions. And that's something that my nation has been doing for 40 years. We've transitioned through many levels, through many different types of treaty. But I think that I foresee, as a leader now, a transition of my nation. And I think what the JBNQA has brought is access to education, where we have a Cree school board that allows you the right to go to school anywhere in the world to do anything that you want. And we face First Nations issues where we have students that are not even using the program to have free school, which blows my mind. So we're in our own rattrapage to catch up with what our treaty has offered. But I also see many students making use of this. We're a young nation, 50% of our population is below the age of 18, and I foresee a tidal wave of bright-minded people coming to the table and supporting us. Cree lawyers, Cree students, Cree advisors, Cree academics, and I think that will be a challenge when there's a transition between old leadership and new leadership, but I think that the Crees have showcased that they're very good in transitioning when met with a challenge. So I foresee that things will be bright in the future.
I hope those young ones will consider the University of Ottawa. I'm kidding, but thank you. All right, so at this point, we're going to thank you to our panelists. At this point, we'll give the audience an opportunity to ask a question if they like. I would just ask you, for the sake of time, to sort of take a moment to reflect on the question you'd like to ask to the panel or to an individual panel member. There's no nice way of saying this. No anecdotes, please. Thank you so much. So, does anyone have a question? Steve, so, no? Okay. Oh, I see one. All right, let's go.
Oh, you do? Okay.
Never give them the mic.
You sound so close.
Oh, sorry.
Sorry. I don't really know how to ask this. I think it's more directed towards you because I'm Algonquin as well, but I'm from Quebec. And I recognize that the Algonquin nation is extremely fractured and we don't work together. That's not even talking about the provincial border that separates us from Quebec and Ontario. And then maybe you guys have something to say about nationhood as well, but what I guess because it's not something that's a reality for us right now, what solutions have been considered in bringing together the Algonquin Nation to talk, even if it's not between provincial, across provincial borders, but as a whole to become a stronger nation, I guess. And like, what have you learned from practice in, like, I'm sure you've had some barriers and challenges in working on this as well, so just whatever your thoughts are.
Yeah, especially the Ontario, like my community doesn't really speak a whole lot with the Quebec communities, and several of the Quebec communities, there's a little bit tighter cohesion. I actually work a lot more with the chiefs on the Quebec side. I don't really work a whole lot with the leadership within my own community. There is the Algonquin Chiefs Council. I know they have an upcoming meeting, and they're going to talk about a few things where, you know, all 10 chiefs will get together. These are the Indian Act chiefs too. This is a fact of colonialism. They dissolved their form of governance and put in this, you know, sort of puppetry government that is accountable actually upwards to the Minister of Indian Affairs. It's actually still the technical definition in law. Not necessarily accountable to us, but if they were organized more into one centralized group, like a tribal council of sorts, where the communities could get together more and speak about it. But I do know that the Quebec communities are frustrated with their disenfranchisement, so they've talked about issues of an injunction. Pikwàkanagàn, for example, has also hasn't, I guess, filed any sort of land claim, I think formally, that they actually have title over here as well, so that could conflict with this and put the brakes on what is the effective alienation of it. So I'd be interested to hear how one gets, especially there's a lot of Cree communities that you had to get on board together to talk about it, and especially a lot of...
Okay.
I'm going to quickly answer her because I think that's a really good question. I am James Bay Cree, so I'm from the Quebec side, and we also have Cree that have married and moved to the Ontario side. And the relationship between the Quebec and Ontario Cree has been challenging. And recently, the James Bay Cree launched a lawsuit to expand their borders into the Ontario side, which did not please the Ontario side, which I completely understand. And the reasoning was provincial borders do not define our territory. That was the Quebec view of it. But I really felt that even though this lawsuit has been in play for 20 years, there was a lack of communication between the Quebec and Ontario party, the Cree parties, where they should have sat down and spoke and clarified and discussed all of the perceptions of what that court case was for. In just to maybe give the positive side, the Cree territory, we've had a lot of relationships with the surrounding nations in Quebec. So recently, this summer, we signed a nation-to-nation agreement with the Innu of Mashkawazìwogamig, which is the neighboring nation right beside the Cree. We share a border, so we now have a nation-to-nation agreement between two nations where we've completely excluded Quebec from that process. They did not sign anything. They were there. They recognized participation at the signing. But I think that kind of blew Quebec's mind, where they were like, hey, what's up? These Native people are signing agreements to get along with each other. So I think that what you said, the discussion and having that relationship building process between nations is very important, because you can achieve it. That agreement, I think, was unique in its own between the Cree and Innu, and I think it showcases that as First Nations, we have to come together and agree, because the strength is in numbers. It's in solidarity amongst and across nations throughout Canada.
Yeah, if we keep it short. I was just actually really terrified of a Cree person and an Inuk man trying to tell an Algonquin like how to define nationhood. But yes, Bruce, you can have 20 seconds.
Okay. No, it's Nunavut is unique because Inuit are Inuit, and they only have to deal with one group, so that's distinct there. The problem that we have is that the consensus public government that we have benefits all the citizens, Inuit and non-Inuit. But the situation there is that 85 or 83% of the total population are Inuit, And so NTI wants to ensure that our rights, Inuit rights and benefits are implemented, but the territorial government represents a lot of the citizens, including non-Inuit. And the problem here is that a lot of the senior officials within the government of Nunavut are non-Inuit. Directors, deputy ministers, assistant deputy ministers, and so they have a lot of say over what happens. So we have agreement at the political level, but at the practical level, on the implementation, it does not get there because these non-Inuits making policies, putting forward this kind of thing. So that is the challenge that we face in Nunavut, but just wanted to talk about that.
Fair enough. Do we have any other questions from the audience? Okay. Leeway, I'm sorry, that's my mom. I can't show preference. I'm so sorry. I'll come see you, buddy.
Okay.
Nope. No,
What's it? I'm from the Treaty 9 territory. That means the northern half of Ontario was signed between the federal crown and the First Nations of Ontario. And the Ontario government co-signed, it says it co-signed with the Ontario representatives. And in 1905 and 1906. But that part of Ontario, where Treaty 9 territory is, did not become officially as part of the province of Ontario until 1912. So we have, it's more complex than all your experiences with your federal negotiations and modern agreements. So I agree with your, your words of experience with modern treaty agreements. They're very important to us. Mandy, you're from northern Quebec, and I'm from northern Ontario. And all our traditions in the Treaty 9 of Ontario are very, are based on the matrilineal system. Traditions is passed on land use and occupancy. And that's conflicting with the federal Indian Act policy, which is based on matriarchal transplanted governments from Europe. I just wanted to point that out, and my question is, I know that we all deal with the Indian Act. We all have to face the Indian Act policy, which takes us to court every time we want to negotiate whatever about our land use and occupancy. So can you give us an answer to this question about the Indian Act policy?
I can try to take a crack at it. I think the Cree are unique because when we negotiated the JBNQA, we actually also obtained the Cree Naskapi Act, which binds us. So we're not excluded, but we're not exclusive to the Indian Act. And when we signed our last agreement this summer, we actually extinguished the Cree part of the Cree Naskapi Act, and we're now developing our own constitution that will recognize what the Indian Act is supposed to be. So to me, that is an extreme responsibility for the Cree to really try to define the ideal Indian Act with the Cree and Aboriginal view of what it's meant to do. So I hope that when this process is done, it can be a model or at least a marker for First Nations to use and moving forward when trying to remove themselves from the Indian Act.
Yeah, a couple comments is that I think that what we see is in the Supreme Court judgments that have come out recently, Chilcotin recognizing Aboriginal title, Daniels finally recognizing Métis, enumeration on what adequate consultation should be in the Clyde River thing. And what is happening there is that the court, looking at the situation, the facts, they're forcing government's hand. And what that means is the government has not been able to enact policies, legislation, practices that honor, respect the treaties. The situation there, in my opinion, is that with the education of the Canadian public and the Canadian public on the street, the views and the preconceived notions about Indigenous people, you know, incarceration, drunks, residential school, get over it, these kind of things, the perception of Indigenous things is really changing. And so until the Canadians and the education about what treaties are, the contributions of First Nations, Inuit, Métis, and Canadians saying, what the hell, Canada, why aren't you doing this? This is fair, this is honorable, surrender their Aboriginal title. Once that grows and is happening, then the government will then respond and treat Indigenous issues as a priority that they should be. So I think where things are bad now, but they're the worst that they're at, and they're only going to get better. The Inuit are looking at this interesting thing now because there's Bennett, Philpott, and Dominic. So Inuits fall under the Diand Act, and it's very short. There's this Indigenous Recognition framework that is taking place now. So I think that the government is changing, and it's going to have some positive changes, but it's as a result of all the things that are happening, and including, unfortunately, litigation. So I think positive changes are afoot, and it just can't happen fast enough.
I'll quickly add, although it hasn't transpired yet, but in our agreement in principle, we would be sort of imitating, because you were the first agreement which almost opts out of the Indian Act. You're no longer, you don't have status Indian per se, right, underneath the, oh, you do, but the Indian Act doesn't govern you in the way. It's sort of a devolution of authorities that are entailed underneath the Minister of the Crown. It's fairly consolidated there, but we would opt out in a way that you had as well in our self-government agreement. So we would essentially and effectively administer the Indian Act in our own community, but not be answerable, I guess. It would be the relationship would be more fiscal with the federal government as a transfer of funds, and we administer it rather than having CERNA, or it's now CERN, Indigenous Relations, provide that sort of governance oversight in the administration of the Indian Act. So, yeah.
All right, thank you for all your feedback. Leeway, did you still have a question? Was it the same question my mother asked?
It's a comment. I'll make it quick because I know we're running out of time. Thank you very much for this presentation. I've learned a lot. It's more of a fascination. Here we're talking about treaty signing that would take, the negotiation would take 10 years, 20 years, 30 years plus. During this time, then, communication power, culture, our sense of place changes. Facebook didn't happen 20 years ago, you know, and so I find it fascinating that we're signing treaties about land and how people will live on this land, and it takes that much time, but by the time it's signed, things would have changed already. So how do we both look to the back and look to the future and make sure that this continuum makes sense for people down the road, so that we're not just signing something that is not going to be relevant for people in the future. It's not really a question. I just find this fascinating. Thank you very much for the presentation.
Thank you, Leeway. But I think that touches on what Mandy was talking about with like this younger generation coming in, like getting educated, and that there's going to be a transition from like a transition from power from the older generations to the younger folk. Do you think the vision they had when they negotiated treaty was one that took into consideration what the youth would look like 20, 30 years later?
I can honestly say that 3 of the negotiators told me we went to that table and we asked for everything that we thought we could. We had the craziest ask, and they had a lawyer who was brave enough and crazy enough to take on a decision to sue Quebec. And I think that everybody around that table was really brave and asked for as much as they could and tried to get the best deal for what they could foresee. I don't think anybody thought that society would be where we are now, but I think they did a damn good job trying to meet the needs. I really do.
I'd say that even though this is in our lifetime, this change is 15 to 20,000 years. This is a severance that occurs in our time right now that may be a big portion of our lifetime. But if you were to ask my ancestors 500, 1,000 years ago, that this event would ever occur, that you're transferring this to another foreign entity, it would be absurd. They would say it's always been ours, and it's actually really not ours. There's principles of land tenure and stewardship in a lot of Indigenous, especially Anishinaabe, which Cree and Algonquin are Anishinaabe people, is that this land doesn't actually belong to us, right? It belongs to the 7th generation. And that 7th generation continues in perpetuity, so we never arrive at this. So we're now actually the Algonquin here on the Ontario side. We are actually the 7th generation now, so we're giving up. We were the last stewards, and we passed it off to someone else. So, yeah, this happened. In the 20-year span, a few things have happened, yeah. But in 1,000 years from now, Algonquins will say, can't get it back. You can't get it back.
From the Nunavut's perspective, take a little different approach. When I first started with NTI, the graduation rate was 25%. Horrible, dismal. What is going on? Now, I'm happy to say it's 39%. And I would say that in that 20 years, and what NTI says is that we can achieve the socioeconomic, social well-being of Inuit through the implementation of our agreement. So that's why we place so much value on the implementation and to follow our treaty. And so Inuit are the best to decide and help guide on how to deal with the social problems and all the other associated things. I would say things are improving, and we just want to see our agreement implemented.
All right, we ran a little long, so I encourage you to maybe hang around and talk to the panelists, but I will take this opportunity to say thank you to everyone for attending today. I hope you enjoyed the food, got something to drink. Very special thank you to our panelists, to Library and Archives Canada for being here today. Check out the Williams Treaty. They have 3 archivists here to talk to you about it. And yeah, thank you so much, everyone. Have a great day.